Please be seated. Before the end of this sitting, I'd like to give the floor to 9 judges who wish to put questions to the parties. I ask each judge, before putting his or her question, to indicate whether the question is addressed at the Gambia, Myanmar, or both parties. Judge Tomka, you have the floor.
Thank you, Mr. President. My question is addressed to Gambia. It reads as follows. A number of witness statements relied upon by the Gambia are anonymized, and Myanmar contends that in at least 4 instances, the same individual appears to have provided more than one statement, sometimes to different collecting entities. Could the Gambia please outline the methodology it employed to verify witness evidence it received from other entities, including whether the Gambia has access to the identities and personal information of witnesses whose statements were supplied by third parties? And second, explain what safeguards, if any, were in place to ensure that multiple statements relied upon as corroborative did not in fact originate from the same individual. Thank you, Mr. President.
I thank Judge Tomka. I now give the floor to Judge Charles.
Thank you, President. My first question is addressed to the Gambia. The independent international fact-finding mission applied a reasonable grounds standard of proof in making factual determinations, which the mission itself described as, and I quote, lower than that required in criminal proceedings. Given that the court has previously applied a so-called fully conclusive standard of proof in cases involving allegations of genocide, in the Gambia's opinion, what consequences does the fact-finding mission's application of its standard of proof have for how the court should approach the fact-finding mission's evidence? President, my second question is addressed to Myanmar. According to the Gambia, and I'm quoting from its oral pleadings, as of 18 October 2018, at least 178 Rohingya villages had been totally destroyed by fire, with an additional 214 partially destroyed. What total numbers of destroyed and partially destroyed villages has Myanmar recorded? And what is the nature of Myanmar's evidence? And the second part to that question is, according to Myanmar's evidence, how many of these villages were destroyed by ARSA? How many were destroyed by the Tatmadaw during the clearance operations? And how many were destroyed by the Myanmar government after the clearance operations? And again, what is the nature of Myanmar's evidence? I have a third question which is addressed to the Gambia. The Gambia points to the occurrence of what it terms widespread sexual violence. Is the Gambia able to identify the locations where what it calls the hundreds of instances of sexual violence are alleged to have occurred? And my fourth question, which has been drafted jointly, it's on behalf also of Judge Ad hoc Pillay, is addressed to Myanmar. And our question is, Myanmar has conceded that it's not possible for it to, and I quote, discount the possibility of incidents of serious sexual assault, end of quote, having taken place during the clearance operations. Our question is, what measures have been taken by Myanmar to investigate whether such incidents took place, and what were the results of any such investigations? Thank you, President.
I thank Judge Charles. I now give the floor to Judge Brandt.
Thank you, Mr. President. I will raise my question in my own name and also on behalf of Judge Cleveland and Judge Charlford in a joint question. And I would like to address my question to Myanmar, or a question to Myanmar. So, first one, how does each party characterize the nature of ARSA, particularly with regard to its representativeness within the Rohingya population, its strain, its estimated size, including the number of individuals it considers to be member and or effective participants, its organizational and hierarchical structure, and its military and weapons capabilities. In this regard, can Myanmar indicate the number and nature of the casualties and the extent of the material damage that it attributes to ARSA during the relevant period as an element informing its assessment of ARSA's operational and military capacity? Second one, can Myanmar explain with specificity how it defines a supporter of ARSA and purposes of its military operation? Third, what specific criteria were used by soldiers on the ground during the military operations to identify persons considered to be lawful military targets, and how they were distinguished from civilians? Fourth, how many of casualties in the various villages, according to Myanmar own records, were, using Myanmar characterizations, members of ARSA or its supporters? How many were collateral casualties of the fightings? And how many of them were innocent civilians? Thank you, Mr. President.
I thank Judge Brandt. Judge Gomes-Robledo, you have the floor.
Merci, Monsieur le Président.
Thank you, President. My question is a question for Myanmar as follows. Myanmar has refused from 2017 until now to grant access to any independent international body that could have investigated the alleged facts at the scene. This would have allowed for the corroboration or, on the contrary, refutation of the facts alleged by the Gambia. What are the reasons for this refusal to cooperate, given that the preamble to the Convention recalls the importance of international cooperation in the prevention and suppression of genocide, and refers in this regard to General Assembly Resolution 96 of the first session of the General Assembly? I would like to recall what the Court stated in paragraph 163 of its 2010 judgment in the pulp mills on the River Uruguay case. I quote, "It is of course to be expected that the applicant should, in the first instance, submit the relevant evidence to substantiate its claims. This does not, however, mean that the respondent should not cooperate in the provision of such evidence as may be in its possession that could assist the court in resolving the dispute submitted to it." Unquote. What conclusions, including with respect to the weight and inferences of evidence provided by the applicant, should the court draw from the refusal of the authorities of Myanmar to cooperate with the bodies mandated by the United Nations to investigate the facts underlying the Gambia's allegations? Thank you, Mr. President.
I now give the floor to Judge Cleveland.
Thank you, Mr. President. My first question is primarily for Myanmar, although both parties are welcome to respond. In its written and oral pleadings, Myanmar has emphasized that, quote, none of the FFM material has been accepted by Myanmar, that reports by NGOs, quote, such as Fortify Rights and Amnesty International are by definition mere hearsay, and that the court, quote, should not give weight to such FFM and NGO reports at all. Myanmar also contends that the media articles in the record, quote, are not methods of proof capable of proving facts. In its rejoinder, Myanmar states that, quote, Myanmar itself does not rely on material of the FFM or the IIMM as evidence of any of the substantive facts of this case. However, after advancing these positions in detail in the oral proceedings, counsel for Myanmar then relied extensively on FFM reports, NGO reports, including Amnesty International and Fortify Rights, and on media articles, among others, to establish Myanmar's allegations regarding the organization and strength of ARSA and its activities in northern Rakhine State, and to suggest an alternative reasonable inference from the evidence. Myanmar invokes these sources for the same purposes in its written pleadings. Does Myanmar contend that the evidence it invokes to describe ARSA and its activities in northern Rakhine State, including FFM and NGO reports and media accounts, form part of the best available evidence in this case? To what extent should the court consider reliable and give weight to such sources of evidence referenced by Myanmar? My second question is for both parties. One point of disagreement between the parties with respect to possible legal consequences involves the propriety and appropriate scope of remedies, including reparation, assurances, and guarantees of non-repetition, if the court were to find that Myanmar's international responsibility is engaged. Are there decisions of other international courts, tribunals, or bodies that either party considers relevant to the propriety or appropriate scope of such remedies, should those questions arise in this case? Thank you, Mr. President.
I thank Judge Cleveland. Judge Iwasawa, you have the floor.
Thank you, Mr. President. My question is addressed to the Gambia. The Gambia is saying that Myanmar is wrong in arguing that the number of victims is relevant to determine the existence of the actus reus of genocide. In the Gambia's view, expressed during these hearings, I quote, "To be clear, there is no numeric or substantiality threshold inherent in the actus reus," end of quote. The Gambia further argues that, I quote again, "To the extent that numbers may ever be relevant, it is a factor that goes not to actus reus, but potentially to the question of whether the mens rea of genocide has been made out. This is because it may, not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with a specific intent to destroy the group," end of quote. At the same time, the Gambia's pleadings so far were largely focused on the number of allegedly attacked and/or destroyed villages, the number of alleged victims, scale, and other numerical elements. In light of these, could the Gambia please clarify to what extent, in its view, the mentioned numbers and the proportions they represent within the alleged protected group are relevant to establish the mens rea of genocide in the present case? Thank you, Mr. President.
I thank Judge Iwasawa. Judge Humut, you have the floor.
Thank you, Mr. President. My question is both for Myanmar and the Gambia. Myanmar suggests that the regime of individual responsibility and that of state responsibility for genocide are two distinct institutions. And the genocidal intent differs significantly when attributing it to an individual versus a state. At the same time, Myanmar argues that there is no distinction between a criminal standard of proof and the civil state responsibility standard of proof when it comes to allegations of state responsibility for violations of the Genocide Convention. Myanmar adds that such a standard is comparable to beyond reasonable doubt standard applied by the international criminal courts and tribunals. The question for Myanmar and the Gambia is whether the difference between the regime of individual criminal responsibility and state responsibility for genocide should be considered when assessing the circumstantial evidence that establishes the genocidal intent as the only reasonable inference. If there exist other motives or objectives for a state, in addition to its genocidal intent, that can be established by such evidence, would this negate the possibility of proof of dolus specialis as the only reasonable inference? Thank you, Mr. President.
I thank Judge Humut. Judge Arak Pillay, you have the floor.
Thank you, Mr. President, for this opportunity. My question is addressed to Myanmar, and of course I invite the Gambia to respond if necessary. Counsel for Myanmar stated as their case that what the Myanmar military was doing was not aggression, but responding to ARSA attacks wherever they occurred in order or with the goal of protecting civilians. And so I would like to invite you to cite instances of how, when, and where the Myanmar military protected the people. I was very interested in the fact that Counsel for Myanmar had access to, I think, what you call military incidents reports that we have not had sight of. And perhaps the military then recorded instances where they went and acted in order to protect the people. Thank you, Mr. President.
I thank Judge Arak Pillay. I now give the floor to Judge Arak Kress.
Thank you, Mr. President. My question is for the Gambia, and I ask it also on behalf of Judge Charlesworth. According to the Gambia, as pleaded orally, I quote, "What matters is that the targeted part of the group that is intended to be destroyed is substantial, so that the targeting of that part is significant enough to have an impact on the group as a whole." End of quote. The Gambia argues that substantiality is established given the, I quote, "sheer number of villages attacked over the 2 waves of clearance operations, the number of people living in each those villages, and the nature and extent of the attacks in each of those villages." End of quote. The Gambia has further contended that, still in its oral pleadings, I quote, "the nature, timing, and scale of these operations is vast, and it makes clear that it targeted a substantial part of the Rohingya community." End of quote. Could the Gambia provide an estimate of the quantitative dimension of those members of the Rohingya community to which the Gambia refers as a substantial part in this statement? In particular, does the Gambia have evidence as to the overall population of the villages targeted in the second clearance operations and of the 178 villages alleged to have been burned or razed during or after the operation? Thank you, Mr. President.
I thank Judge Kress. The written text of these questions will be communicated to the parties as soon as possible. The parties are invited to reply orally to these questions during the second round of oral argument. No written comments are envisaged. The court will meet tomorrow in closed session for the examination of the witness called by the Gambia. During closed session, only the judges, limited registry staff, interpreters, members of the party's official delegations will be permitted to be present in the Great Hall of Justice. I recall that the witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January, 2026. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January, 2026 at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. The sitting is closed.